And how long can the popo actually hold you on a traffic stop? Here's what most people get wrong, or do people really think about this? They may think there's some magic number and there's, 15 minutes, 20 minutes. And after that, they're free to go. That's not how the law works. And not knowing the difference could cost you. The U.S. Supreme Court has never set a specific time limit on a traffic stop. What they did say in Rodriguez versus United States 2015 is this: a stop becomes illegal the moment it goes beyond the time needed to complete its mission. That word, mission, is everything. The officer's authorized tasks are limited. He can check your license, registration, proof of insurance, run you for warrants, decide whether to write a ticket or issue a warning. That's it. The second that paperwork is done, his authority to hold you is done. But here is where it gets real. In the Rodriguez case, an officer delayed a driver by 7 minutes after the ticket was already written to run a drug dog around the car. 7 minutes. The Supreme Court said that was unconstitutional. An unreasonable seizure under the Fourth Amendment. 7 minutes cost that entire case. So what does that mean when you're sitting in that hot seat? If the officer has handed back your documents, license, registration, ticket, or warning, that stop is legally over. He cannot hold you to ask unrelated questions. He cannot make you wait for backup to show up, not without new independent evidence of a crime. He cannot run a dog around your car, not without reasonable suspicion separate from the traffic stop itself. If he does any of that, that detention may be an illegal seizure, and anything found could be challenged in court. Now, you know the clock, not a stopwatch, a mission clock. When the mission is done, so is their authority. Don't give it to them voluntarily. Let's talk out a few of the other cases that you should know regarding traffic stops. Case 1, Illinois versus Cabal, 2005. Roy Cabali was pulled for speeding in Illinois. While the ticketing officer ran his plates, a second officer walked a drug dog around the car. On his own, unsolicited, and the dog alerted. Drugs found. Conviction upheld. The ruling. The Supreme Court said the dog sniff was constitutional because it happened during the stop. It didn't extend it past its mission. This is the direct predecessor to Rodriguez and the perfect contrast case. In Cabais, the stop's mission was still running when the dog went around the vehicle. In Rodriguez, the mission was done. That's the line. In 2005, the Supreme Court said a dog sniff was fine, if it happened while the stop was still active. So they learned they started running dogs before the paperwork was finished. Rodriguez closed that door in 2015. Case 2, United States versus Taylor, 6th Circuit, February 2025, called the air freshener case. Nathaniel Taylor was pulled over doing 69 and a 55 on I-275 in Knoxville. Routine stop, insurance found. No ticket written yet, but Officer Cox called for a K-9 unit before finishing the citation based on multiple air fresheners on the gear shift. Taylor's criminal history. His travel plans said he was coming from a job interview. K-9 arrived, alerted, search found no drugs, but found a firearm in the trunk. Taylor, a felon, was charged. The 6th Circuit reversed it. Air fresheners plus criminal history plus travel explanation equals not reasonable suspicion. Evidence suppressed. Why this matters. This is Rodriguez applied to real street behavior. An officer strategically delays the paperwork to buy time for the dog. The court said that's still unconstitutional. Air fresheners in the car, a criminal history, a story about a job interview. The officer thought that was enough to call the dogs. The 6th Circuit said, no, that's not reasonable suspicion. That's a hunch. And hunches don't override the Fourth Amendment. Case 3, United States versus Martin, Fourth Circuit, April 17th, 2026. A very recent case. A U.S. Forest Service officer stopped Nathaniel Martin for an illegally parked vehicle. While waiting on license and criminal history checks, the officer pivoted, started questioning Martin about ginseng poaching, a totally unrelated matter. The Fourth Circuit reversed the conviction. The court held the officer abandoned the stop's mission from the outset by pursuing criminal investigation into unrelated activity while awaiting routine checks. Key language from the ruling. Officers cannot use the time waiting routine checks to conduct collateral criminal investigations. Why this matters? This is the freshest application of Rodriguez on record. And it goes even further. The officer didn't even wait until the stop was done. He abandoned the mission in the middle of it. This is a direct warning shot to law enforcement nationwide. The court said that's not a traffic stop anymore. That's an investigation. And it needed its own legal justification. The mission was parking. He abandoned it. Evidence gone. Case 4, Wren versus United States, 1996. The case that started the game. Officers in a high drug area stopped for a minor traffic violation, but the real reason was drug suspicion. Cocaine found. Argued the stop was a pretext. Supreme Court ruled unanimously, as long as there's a valid traffic violation, the stop is legal, even if the officer's real motive is something else entirely. This is why pretext stops exist. Officers can use any valid traffic violation to pull you over legally. But here's the thing, Wren gives them the key to open the door. Rodriguez dictates how long they can stand in the doorway. Wren said they can pull you over for anything. A rolling stop, a cracked taillight, drifting 2 inches over the line. That's legal. But Wren doesn't give them unlimited time once you're stopped. That's where Rodriguez takes over. If this video gave you something you didn't have before, share it. Not for me, but for the person you know who's going to be in that seat and won't know what their rights are when it matters. And that's the whole point of this channel. Hit subscribe, because the next episode goes even deeper. We're talking about what you can and cannot be legally ordered to do once the stop is over. Can they order you out of the car? Can they detain you after handing back your license? Can they search without your consent? And
the right
what
of the
does
people
your
to be
consent
secure in their
actually
persons,
cost you?
houses,
Look out for the next
papers, and
episode that's
effects
coming. Don't
against
miss it.
unreasonable
Thanks,
searches
be
and
safe.
seizures shall not be
540.
violated.